Good evening, this is Rahul Reddy. Every Tuesday from 5 p.m. to 6 p.m. Central Time, Reddy Neumann Brown does bring in immigration updates. Along with me is my business partner, Stephen Brown. Stephen, what do we have today to discuss?
Yeah, Rahul. So we're going to talk about a few topics. We're going to talk about this increase in STEM OPT extension RFEs we started seeing in the last month or so. We're going to talk about advanced parole delays, kind of how to handle that, maybe from a litigation solution. We're going to talk about what the options are for documented dreamers, when they sit there and turn 21, and the H1B visa reaffirmation process when they go for visa stamping and Department of State sends it back to USCIS.
Coming to the topic of the STEM extension, as people know that if they do have a STEM degree, either bachelor's or master's, after their 1 year of OPT, they get to extend for next 2 years if they are employed with the e-verified company, Stephen, and they're working in the similar field for which they got their degree in. Now, what's the new trend that we are seeing? Why is that? Are they doubting every company is a fake company? What exactly is the intention of the USCIS to issue so many RFEs on the STEM extension, which is unprecedented, though?
Yeah, I really don't know. I don't even see, I'm looking at one that I received, and we started seeing a couple of these pop up late May, early June, and I got one yesterday, Rahul. I know you got one over the weekend, and I said, hey, we both talked that maybe this is worth talking about because it's popping up a lot. There's no analysis, right? When you get an H1B RFE, you see, hey, you have to show specialty occupation, you submitted da-da-da-da-da, this is why we don't think that it's a specialty occupation. The one I'm looking at here is just the normal language, that's boilerplate about when you have to turn it in, and then please submit evidence for all your prior C3B employment. That's the OPT employment with with the company, including but not limited to, and it's letters from the employer, pay statements, personnel records, EIN, stuff like that. And I don't know if this is just an increase of people filing online and not properly submitting the documentation, or if this is, remember, Rahul, back in 2018, there was this push against consulting companies for using STEM OPT at third parties. So I don't know if they're just trying to make sure these employers are legit. We know, right? Integra, all these companies that had a lot of fraud through OPT, it was easy, right? That you cut a letter, you go to the DSO. So maybe USCIS is trying to head it off now instead of being reactive. And, they're going to just require more RFEs to ensure that everything is valid. So I don't know. I don't know why it's popping up.
Stephen, if I get an RFE and the STEM extension, if I approach you, what documents would you require from me? And what do you respond? How do you respond to the USCIS?
Yeah, so I think, the big thing is each RFE is going to be different, but the ones that I've seen have that list of job duties. I'm going to want your pay state, or excuse me, not job duties, the list of required evidence. I'm going to want your pay statements. I'm going to want a signed letter from your employer confirming the job opportunity, any sort of offer letter, official personnel documents, your company's FEIN, anything like that can help me show that there is a real employer-employer relationship with the STEM OPT student.
Okay, and then what's your strategy in responding? How different is it than the H1B RFE?
I think it's not going to be much different at all. I think it's going to be very similar that, the employer-employee relationship throughout immigration is not a hard stance. It's basically, are you going to be employed, right? They have we remember the old right to control. Well, that was a subset of how you could show that they have the ability to hire, fire, pay, supervise, or otherwise control. Well, if they have that offer letter, they're paying you, they have that job confirmation, I think that's sufficient to go with the black letter way of looking at employer-employee relationships. So I do think it's worth taking a look at these seriously, because the downside of not properly responding is big, right? You lose out on 2 years work authorization. With the H1B lottery being what it is, you want to kind of maximize your opportunities. in that, using that STEM time to help. As an attorney, from a legal perspective, right, if you have a real employer-employee relationship, you have a job offer, you got paid on OPT, this doesn't concern me. That I think we're going to be very successful in responding, and if that changes, we'll let y'all know. But I think you do need to take it seriously, but it's not something as an attorney that I'm panicked right now on doing. I just think you guys should be prepared and know.
I would strongly recommend that if you get an RFE, take it very seriously, because if you just misfire it, it's going to get the denial of the STEM extension. And then that means that most probably, you'll have to leave the country, because then you don't have an option of getting the H1B in the near future if you're not already got the H1B. So take it very seriously when there is a STEM extension. Stephen, now we know that a lot of people have filed adjustment of status in October of 2020. Some of their priority dates were current at some period of time. They got their green cards, and some of the people priority dates have backlogged and they are stuck in the 485. And of course, a lot of lawyers and good lawyers advise these people to stay on EADs, which they are adjudicating the EADs at proper timings. You don't have to go to court to fight for any EAD, at least recently, especially on the adjustment of status EAD. Yeah. The extensions are getting approved in due time. Now they have a 540 days extension. If the EAD extension is not yet approved and you filed a timely extension. But when it comes to the advance rule, the same rule of 540 days is not there. Not only that, the time that they are taking for the adjudication of the EAD, which is anywhere between 2 months, the maximum of 5 to 6 months, but that's not true when it comes to the advance parole. They are taking up to 18 months. Now, there are some cases where they're adjudicating along with the EAD, which are coming in 4 months, but a good number of cases are taking a long period of time. And these people cannot travel while the advance parole is still pending, and the existing advance parole has already expired. Now, of course, people are contacting the congressman 2% of the time or 1% of the time, it may help. Ombudsman, 2% of the time, 1% of the time, it may help. They are also raising a service request for emergency, and they're also calling the USCIS for emergency advance parole, which is helping in 1 to 2% of the time. But the total percent of the time which all these things are helping is less than 5%, if not maybe 6%. But still, there are a lot of people who want their advance parole. What is the litigation option? When can we go to the court? Hey, they're supposed to adjudicate how many days they're supposed to adjudicate the advance parole, and can we go to the court on this one, Stephen? What is your experience on the advance parole?
Yeah, we've taken a lot of these interim benefits, the EAD and AP, and I'm going to use that phrase because it's what I'm used to using, but we'll primarily focus on the advance parole for the conversation. But we've taken these cases quite a bit and seen very good success. Anybody that's listened, when we file a lawsuit, we serve the government usually within about a week of filing, and they get 60 days to respond. And knock on wood, for the most part, they're making decisions on those advanced paroles. Now, from a timing perspective, and again, each case is going to be unique. But I look 4 to 6 months that it's been pending. I think there's really good language, anything beyond 6 months. I think 4 months we could be a little aggressive, especially if you have travel. Keep in mind, these travel documents, the advanced parole, it takes, I think, 17 minutes, if I'm not mistaken, when USCIS did their fee regulation proposal in January 2023. So they're not time-consuming documents. Ultimately, the only part of this that is any different from the EAD is whether you're in the U.S. or not, right? It's very similar. It's a 485 pending. Now, from what I have heard from rumors of people that have been in meetings with USCIS, is that they view every advanced parole application as they need to exercise their discretion. They believe advanced parole is discretionary. And I think they're confusing the idea of parole and advanced parole. And I could go on my soapbox on that. We are fighting a case in DC on why we think advanced parole should be automatically extended in accordance with the Administrative Procedure Act. And they're making that argument that parole is discretionary. And I agree. Parole is discretionary, but I don't believe the issuance of the document is. So when you have your advanced parole document, when you go in to CBP, you have permission to seek entry, and then they parole you in. And yes, they can deny entry for a number of reasons. It doesn't happen a lot for advanced parole, but let's say you have a criminal background. They can deny your entry, and that's discretionary. But the document itself isn't. So we've done a lot of these lawsuits. Thankfully, a little bit less as people are getting the 5-year ones. Which is great. And, we've done more green card ones, which if you're current, that would be my suggestion to you. Fight on the green card. That's more important than the advanced parole, that we can kind of tie the two in together. But yeah, I think, these are great cases. I think they're some of the silliest delays we see.
Okay. I want to touch the topic of the document dreamers, guys, those people who are getting aged out, the children who have been brought into United States, who maintain their legal status. Unfortunately, the government doesn't give them employment authorization unless they are eligible otherwise in the adjustment of status application. So what are the steps that they need to take? I recommend a lot of these children to tune in to Reddy Neumann Brown. The reason is that you guys are immigrant, you come into United States on F1 or H1, you have gone through the hurdles, you know what these things are, but you need to prepare your children, the journey, if they want to stay in this country, United States, they need to have the aspect of what is immigration. They can't depend everything on it. You can't take care of them every little step that as they go. And maybe you will return back to your home country, but they're going to stay in this country. They need to learn the process. So they need to experience it. They need to learn it. If you have any teenage kids, I would say, at least at the age of 15 or 16, you need to hook them up to Reddy Neumann Brown. The reason is that as they stay in the United States, they need to get aware that they are not U.S. citizens. Fortunately or unfortunately, I don't know, it depends on how you take it. These people are staying legally in the United States. Now, the reason I say sometimes unfortunately is because the government gives benefits for some people who are not documentarily present in this country, but it doesn't give benefits to the people, employment authorization, to the people who are documented in this country. So unfortunately or fortunately, these documented people, they need to learn that eventually they will move out of the shadows of their parents, and they have to get to F1 visas, they have to get to the H1 visas, they eventually might want to go to the green card process. What are the prospects available for them as they move on from F1 to H1 to the green card? It's going to be a long journey for them, and they are supposed to be aware of it. We recommend everybody to come tune in to Reddy Neumann Brown. Anybody who is above 16 years old, who is born outside the country, who are here on L2 or H4 or any other dependent visa, we want them to understand it. It's going to be a long journey, so they have to be prepared. That's the only way to prepare is, please come and join Reddy Neumann Brown. Every Tuesday, we will bring in the necessary aspect that they need to understand. At least for the first 20-25 minutes, they need to listen to us. Any other suggestions that you have?
No, I think, we talk a lot, or I try to talk a lot about immigration planning, right? You got estate planning. What's going to happen? It needs to be immigration planning. What do the next 5 years look like? What do the next 10 years look like? And the age out children, the documented dreamers, are one of the biggest failures Congress has had, right? Every parent that I talk to who is exploring litigation on their 485 or exploring EB5, right, to get out of the green card backlog, they obviously want out of it for themselves, but their primary focus is their kids, right? I wish something would happen and Congress would. They tried in February. There was a bill that was proposed that would work for the H4 documented dreamers. It didn't go through, but it's something I do think you need to take seriously and talk to your kids and let them make those decisions on how they want to go about their life, or that way they're prepared, and you're not doing this when they're 20 years old and turning 21 tomorrow, right? Because if we start thinking early, there's so many kids that are very bright, Rahul. I mean, some of them might qualify for different routes. Maybe, I've seen, some kids that might entertainer type, YouTube, all that. And I talked to an attorney that does that with O1s, and there might be other routes. And I think it's just the earlier you think, the more options you have.
With regards to the H1B revocation notices, only USCIS can revoke for any wrongdoings for H1Bs. As sometimes when people go to the consulate, Stephen, they don't. The consulate sends it back to USCIS, because if they don't like that person to get the H1B, they send it back to the USCIS for them to work on. How does the process work? Can you explain that, Stephen?
Yeah, so interestingly, this is why we sue both USCIS and Department of State when we have our 221G delay litigation, so we can keep USCIS's feet to the fire. So when you have a 221G, Department of State views that as a refusal. They'll go through the process and decide whether you should be issued a visa or not. And at a certain point, if they decide no, you should be denied an H1B, and it might, it's not an inadmissibility issue where, you have a criminal background or a health issue or fraud or something like that to the consulate, but they might want USCIS to look into the petition. They send it back, they refer it back to USCIS to review. And we see this is where the problem lies, Rahul, and this is why we sued both, is that USCIS has no timeline to do anything with that referred back petition. I've seen some go very quickly. I've seen some go a year, and it's just sitting there with USCIS, and they can either reaffirm the approval or they can move to revoke it and send a notice of intent to revoke. I'll give you a great example. For whatever reason, and we use this line in litigation, Department of State has quite literally not gotten the memo about the employer-employee relationship rule, the Neufeld memo, right? And they still will sometimes ask about contracts and end client letters. And if you can't provide them, even though you're not legally required to, they'll send it back to USCIS. And a lot of times when it's that issue, I've seen USCIS just affirm it and send it back. Other times I've seen them, send FDNS or send FDNS emails and, eventually send a notice of intent to revoke. So I guess the big thing is this is not uncommon. I think the biggest issue I have seen, Rahul, is when we have some of these 221Gs go for a very long time, that the employer terminates the individual, right? It's been a year with the consulate. They've been abroad. Now it's been a year, and the employer gets, a year and a half later, gets a letter saying, hey, respond to this. Well, they're not going to put effort and time and money into responding to something for somebody that they terminated. There's arguments I think the employee can make there. They're a little bit nuanced, but I do think you should keep that communication up with your employer to, hey, if anything happens, let me know. And you can at least then talk it with an immigration attorney about some of your options.
Let's go to the questions, Stephen.
Yeah, I saw two that I wanted to address real quick. NJRK. So both of them ask about H4 EAD with the Loper case that got rid of Chevron deference. NJ asked if there's a case in the DC circuit about getting rid of H4 EAD, and RK asked about Chevron. Both of you had recommended. I did a live session yesterday with Area 51 podcast. Two great guys, me and Brad Banis from Banis Law, talked about Chevron and the impacts on immigration. The H4 EAD case, NJ, that you are referring to is dead. It was fought through. The court ruled in favor of Department of Homeland Security because there is a broad recognition that DHS can, govern work authorization. I actually looked at it again today. Chevron in the H4 EAD lawsuit is only mentioned once in a footnote, and it says we don't have to apply Chevron because the regulation is so clear, or the law is so clear. But I did a whole hour on this with my colleague Brad Banas and the Area 51 podcast guys. I don't want to take too much today going through Chevron. I'd recommend you check that out.
NJ is asking the question, what about TV Asia thing, Rahul? What's going on with that? Well, they had some issues, so I don't know whether they're going to continue or not. But we're going to be Sunday night live. We're going to be from next week onwards, not this Sunday, but we're going to be live coming on Sunday on July 14th onwards. We're going to be live coming on. Question from
Raj. I-797B with another employer for H1B cap fiscal year 2023 got picked in H1B this year for another employer. Can his employer file a new petition based off for this year? I would hope they already did. The deadline for this year's cap was yesterday, so I would hope that they already did. But if you haven't received, if you've received a visa stamp with that one from last year, you can use that. If not, and you haven't filed a petition, I think you're kind of out of luck now.
The Explorer has a question. Can I travel on EAD and AP outside the country when I'm unemployed? Assuming you are the main applicant, though, no, don't travel. That's number one. Number two, if you are unemployed, though, you will be risking your 485 application. I strongly recommend you contact an immigration lawyer.
Charan asks, I was laid off on H1B, applied for H4 EAD together. They're still pending. Can I go back to H1B when I get a job? If so, what are the process? Absolutely. It's a little nuanced in that your H4 is still pending, so you technically aren't in status. But I think that if I was advising your employer, what I would do is file the change of status from H4 pending back to H1B. In March 2023, USCIS put out guidance about options for terminated non-immigrant workers. And they talk about using a B visa and then going off of the B visa pending to go back to H1B, and they'll adjudicate both of them together, put you in the B visa and then H1. And I think the logic would continue the same for H4. I would have no problems filing that case and submitting the guidance from USCIS.
Stephen, I want you to prepare to answer the question of Sai Kumar, the latest one in the YouTube. Can you check the question, please? In the meantime, I'm going to address other questions, but I want you to answer that because you're more into non-immigrant visa than I am. Mr. Patel is asking the question that an advanced parole, how long a person can travel outside the country is an advanced parole for 5 years. Can he go for education? It depends. Are you the main applicant that filed for the green card? Definitely the travel time should be minimal. I would say less than 3 months. At the most 4 months, probably less than 3 months, that would be better. If you are the dependent, for example, you are a child and you're going, yeah, probably 6 months is definitely okay for you. I would definitely limit the time for less than 6 months, not more than 6 months. But if you're a dependent, if you have any plans for more than 6 months, I definitely recommend that you contact an immigration lawyer.
So Sai Kumar asks, RFE for F1 asking for prior F1 academic year bank statements. Uncle took care of him for 1 semester for tuition. Will that be an issue? I don't think it will, Sai. I think, one, I'd have to see the RFE. A lot of times the reason they're asking for bank statements is they want to show that you are living by the college, right? And, we know these colleges, some of these colleges don't require you. They have you fly in once a month, once a semester. That's usually why I see bank statements for F1 issues. But in terms of paying, the ability to pay for the program, I don't think it's going to be much of an issue. I don't think it's going to be much of an issue that your uncle paid for, because the issue is you have the ability to pay, and I don't know why they would prevent a family member from paying.
Mr. Vivek has this question. My cousin got an F1 visa. His university is in Virginia. He's traveling first time to USA. Can he halt for 10 days in JFK in order to visit me and travel to Virginia when the university starts? Absolutely not a problem. As long as he has travel plans made to Virginia, though. Sometimes from JFK, if you're driving him to Virginia, which is not that far, that's fine too, as long as that he will be able to articulate that he will be staying only for 10 days. After that, he will be traveling to Virginia. That's not a problem at all.
RB on YouTube, can I work in L status and in parallel apply for H4 EAD until it's approved? Absolutely. So if you're on L1A and you're going to do your change of status to H4 EAD, you can continue to work on your L status until the H4 is approved. The only thing I'm going to recommend you keep an eye on is the timing of everything. If your H4 gets approved and there's a gap between H4 and H4 EAD, you can't work on H4 until the EAD is approved. And if that happens, you either stop working or do the margarita switch to get back on L, and then margarita switch back to H4. But there's no issues with that.
Okay, Stephen, there's too many big questions asking now. I know that the way you expressed this was a little bit too legal.
Okay,
let me ask you the question. Now, in the circuit, what are the chances right now, the court case that's there? Are they going to remove the H4 EAD? Or are they going to continue the H4 EAD?
So right now, there is no court case against the H4 EAD.
In other words, H4 EAD is safe right now.
Correct.
There's no court case. Whatever court case was there was dismissed. Is that right?
Correct.
Okay. Just too many questions coming on that.
Yeah. And again, I highly recommend, I've got it up on my Twitter account. Take a look. We did a video on this yesterday. I do not think H4 EAD is in immediate jeopardy because of the Loper decision from the Supreme Court late last week. I think agencies can still create regulations. There's still going to be some look at all that. And then on the immigration side, there is wide discretion, vast discretion for the executive branch, for DHS, to create and grant work authorization. And when you look at the OPT lawsuit that went in favor of OPT, the H4 EAD lawsuit that went in favor of EAD, that's what they relied on, is that there is this wide discretion. Chevron is not mentioned in the H4 EAD case except as a footnote saying we don't have to do Chevron.
So H4 EAD is safe right now. There is no case pending against it right now.
Correct.
In any court as of today, which is July 2nd, 2024. If
as far as I know,
any updates, we will bring it. You come to our show, we'll bring it.
Yeah, absolutely. AJ asked a question. Company filed H1B, has an RFE to establish the petition properly corresponds with the position. That's a mouthful, petition and position. MS in computer science and the roles full stack developer. AJ, yeah, it is fairly normal in that USCIS doesn't employ computer professionals to adjudicate these. And again, it could just be depending on how your petition was put together. One thing I tend to like doing is getting an expert to opine on it. There are companies out there that do these evaluations for immigration purposes. They have professors doing it. And I think those add a lot of weight. You might want to look at that.
My spouse and I traveled to Mexico and returned using automatic visa revalidation. But my spouse's I-94 is not extended based on my I-797. What are the options to avoid the employment discontinuation? A couple of things. You could file a H1B amendment in a premium processing. That's one thing. Second thing, I don't know, have you flied or you drove though? Typically when you drive, sometimes they don't extend it. When you fly, 95% of the time, when you show the H1B, they should extend. Now, if you flied and they didn't extend it, definitely I would recommend to fly it again. Do it again. You have, assuming your wife's I-94 is still valid, the current status is still valid, then she can fly. She can fly again.
I've seen a couple questions on predicting the August visa bulletin. Wrong people to ask. We're really bad at guessing. If I had to guess, I don't think we're going to see a lot of forward movement. We're kind of at the end of the fiscal year, getting closer to them using, hopefully, a majority of the visas that are available. And so I don't think we'd see a lot of forward movement here in the next couple of months. Hopefully I'm wrong, but I wouldn't bank on it.
A lot of people are asking the predictions of the visa bulletin, guys. We are not expecting much movement we're not expecting much movement, especially from the EB2 and EB3 category right now.
Question. I had seen this one pop up. Any outcomes from yesterday's Asian Pacific Islander seminar conducted by DHS? I did not see the notes on that. I can tell you if that is the White House group, it is. They can make suggestions, but they have no rulemaking other than have DHS officials right there. So I'm hopeful. I've seen some really good proposals from that group. I'm hoping DHS listens to them eventually here. One of them being the going beyond the 60-day grace period, maybe making that a little bit longer. The I-140, EAD, and AP. I think those are all within the agency's inherent authority.
RB is an L1 visa. He applied for the H4 plus EAD. His question is that until the H4 EAD is approved, can he continue working on L status? Absolutely, you can. Now his question is that once the H4 plus EAD is approved, what can he do? Well, it's up to you if you want to continue or not. Once you're in H4 EAD, it's not a must that you have to work, but it's your option if you want to work. You want to work for the same company that has L1, you can. If you want to work for a different company, you can. If you want to sit at home, you can. If you want to work for company A and company B, you can. On H4 EAD, you can.
Soham asked a question I'd like to address. That my AOS EAD extension was approved for 5 years, but the AP has still been pending for 4 months. Still maintaining his H1B, which is expiring this September. Would you recommend not renewing the H1B and move to EAD? Yeah, I don't see any reason. So I haven't figured out why, but a lot of folks want to maintain both, right? Their EAD and their H1B. And I know there's some practical considerations of just, hey, if something happens to my AOS. I can tell you that if your I-140 is approved, you don't have a criminal record, you don't have immigration issues in your past, I have not seen too many adjustment of status denials. Every time I talk to someone about litigating adjustment of status, we did about 150 of these starting back September 2022, me and Banas Law. We knew of 2 denials. One didn't maintain status prior to filing, and one admitted to immigration fraud to me and to the officer. And those are the only 2 denials we saw of adjustment of status. So I think it is very safe that if your I-140 is approved, you don't have an inadmissibility issue, right? You haven't committed fraud, unlawful presence, anything like that. There is no reason to keep doing the H1B and stressing about both. Just move over to that EAD, do whatever you want, have that freedom of mobility here.
Well, there is one other 485 denial that I would say that the person was working on software developer, Stephen, and then he applied for a liquor license. In the liquor license, he said the only job he does is a restaurant manager. USCIS issued an RFE on it, and that got denied. So out of the thousands and thousands and thousands of cases that Reddy Neumann Brown comes across, very rarely we see the denials. So, but of course, there are lawyers, the fear mongers, and all those things. They try to extract money because if you maintain the H1B and then you maintain the EAD and then you maintain advanced parole, lawyers make more money, and they do recommend it. But I personally, when I was in adjustment of status, when I was in non-immigrant status, that was a long, long, long time ago, okay? I'm not going to tell the time because that will reveal my age. So long, long time ago, I did let my non-immigrant status go and started using the employment authorization. I did that. Given the chance again, if I am in that position, I am going to do the same thing. Raj is asking the question, can I travel outside to USA for vacation while amendment or extension is in progress? I don't recommend if the amendment is in progress. I strongly recommend to get it approved because when you have one department which is pending, you're going to another department to extend it. I do not recommend it. Is it absolutely needed? Maybe not, but I strongly recommend that you do not travel. One option you have is that you can always get it approved in adjudicated in premium processing, and then make the travel plans accordingly.
MS has a question. July 1st has passed. H1B petitions for the cap season are supposed to be in. Any chance of a second lottery this year? It is way too early to tell. We don't get all the statistics. I mean, we know what ours is, but look, we have a small number of the 100,000 that were selected for 85,000 visas. Um, we have never gotten advance warning of a second lottery. It always is we start getting these emails that, hey, we've taken action on your case, and we log into the My USCIS portal and see selection notices. So I will say this, as we did for the lottery this year, last year, we're going to keep an eye on it. Once I see rumors that I can substantiate or from sources that I trust, or we start seeing it on our own, we will go live very soon after and talk about it so people know. I'll have it up on social media because, like I said, I've seen lawyers who I trust on it. Will put it up, and whether it's us or them, I'll let folks know.
Sapta has this question. I got my green card approved. Is it legal for my employer to hold my green card copy along with the I-485? After approval of the green card, do I need to stay for 6 months after I get the green card? First of all, green card should be mailed to you directly. It should not be mailed to your employer. No, your employer cannot keep your green card. And just in case, by any chance, they refuse to give it, you can always go online, fill a thing called I-90s, and then get a green card. That's very easy to get it. You don't even have to contact a lawyer. You can just go online. It's fill an application, and it's called I-90. Do I need to stay with the company for 6 months after you get the green card? Absolutely not required. You can leave the job if you want to within a week after you get the green card. And people ask me the question, do I need to be in a similar job? No, you can move to a different job if you want to. You can be an Uber driver, you can be a lawyer, you can be a doctor, or you can be a Microsoft CEO. It doesn't matter once you get the green card.
The only thing I caution people on is that your work still has to be legal. And we see this a lot, unfortunately. And I don't think it's people out there trying to be big crime bosses, but where states where marijuana has been legalized, we see it pop up a lot where people are running businesses or running businesses that support it. I mean, I've seen people who are doing technology for marijuana companies, right? They use SAP platforms too, right? So that would be my one word of caution. You can do anything as long as it is federally legal, not just state legal.
Thank you. Thank you for adding that, Stephen.
Shalani heard H1B petition. Any chance of second lottery? We don't know yet. I have not seen anything to indicate that, I think our file rate was higher this year than last year. I think it's pretty on par. I mean, look, there's going to be business needs that have changed. People decide they don't want to immigrate anymore, whatever it might be. But I don't think there's this, what we've seen in the past, Rahul, right, that's led to the second lottery is all of these fraudulent filings, right? Okay, I mean, shoot, last year we had 750,000 unique registrations, and that number has come way down with the new lottery regulation where it's based off of your passport. So if I had to bet, I'm not betting on a second lottery. I'll be pleasantly surprised because I follow the Reddit and Telegram and WhatsApp, and I know there's a lot of people that are anxious for a second lottery. So I do, hope that happens, but I'm not holding my breath yet.
Ajay is asking the question. I filed an H1B, got an RFE establishing a petition whether the pro-offered position requires a specialty occupation. I have a computer science and it's in a software position. So Ajay, it's yeah, we see that sometimes, even though you have a computer science degree, the position must also require a computer science degree, though. So yeah, we do see that quite an often. Even though in the Trump era, though, we used to see a lot of them. Right now, we do very less of those RFEs as compared to what it was in the Trump era.
Chandra asked a question. We actually were talking about this at our meeting today. Can an Australian citizen staying here on an E3 visa apply for an employment based green card? And I'll give you the answer of the lawyerly answer of yes and no. I think so. E3 visas do not allow for immigrant intent, meaning that when you enter the US and you apply for your E3 visa, your intent cannot be that you're going to immigrate permanently. And anytime we talk about immigrant intent, it's up to you to prove you don't have it, not for them to prove you have it. However, there are a lot of ways to structure a employment-based, a investor-based, or a family-based green card for visa categories that don't allow immigrant intent. I would strongly recommend you talk to a lawyer who has experience in that, whether you set it up as consular process or how you structure it can make or break this, and also understanding how to do this. One of the things I tell a lot of my clients is that especially if you're an Indian national, just because you have a green card application with a 2024, 2023 priority date, well, your immigrant intent really doesn't come into play for another 50, 60 years, right? When the priority date's going to get current. So I think it's something you need to keep an eye on and kind of look at how to do it.
Zuruf has this question. He's on the 7th year of H1B with a perm pending. He got laid off and he doesn't have an I-140 approval. Can he join some other company because he's on the 7th year and he's not working with the same company that filed the perm? There are two issues here, though. One is if the perm is still pending and if the company has not withdrawn the perm, yeah, you can, or if the perm has been approved and it's been less than 6 months that the perm has been approved, you still can move to a different company, extend the H1B. Now, under limited circumstances, so yeah, even if the perm has been withdrawn, we have seen that you could get up to the 7th year limit, the validity of the H1B, you could get it with a new company too. Amar is having the question. He has moved from H1B to H4 and his H4 change of status is approved. His H1B stamping is still valid until 2025. Can he travel to India and come back on H1B because his H1B stamping is valid? The answer is no, because you don't have a job anymore with that company. You don't have any job here, so you cannot come on H1B. If you want to go to India and come back, you have to get the H4 stamping and come back.
As Reddy asks, EB2 priority date 2014. Child is also dependent on his U visa. If we get the EAD and SSN through the U visa, will the child block? I would strongly recommend you talk to lawyers that deal with U visas. U visa is a non-immigrant visa. There is a green card path, but I do not believe, and as Reddy, I would strongly recommend you talk to someone, but I don't believe your child's age locks just because of the U visa. I think you have to get the green card, but I could be wrong there.
Hari is asking the question, is there any way that you could assure that my kid age is locked? I-140 approved kid is in 17 when AOS has been filed. Now, there are a couple of things people miss, though. It was current in chart A for a few months, which is good. For the child age to be locked, the 4 things has to happen at the same time. They cannot happen at the different timing. The 1, the child has to be under 21 It's legally under 21. There are two different ways though. CSPA 21 and regular. So if the child has to be under 21, the 485 has to be filed. The dates have to be current. The fourth one, a lot of people miss around that, is the I-140 must be approved. A lot of people miss that thing. The four things have to happen at the same time. Your priority date may have been current, but at the time when the priority date has been current, was the I-140 approved? If the I-140 is not approved at that point of time, your child is not locked. I normally recommend when you have a doubt for these things, it's better to consult a lawyer and get the things in writing from a lawyer that under the current adjustment of status, if my child is locked under the CSPA, because I normally go through A, B, C, D. I write it down, I make sure that the child is locked. And if the child is locked, then I send an email to the father or mother, hey, your child is locked because you told me that you filed the 485 for your child, your I-140 was approved on so and so day, the priority date was current because I checked the visa bulletin myself. I don't trust anybody on those things. And you said that your child is under 21 at that point of time. Based on this information, your child is locked. And if the child is not locked, then I tell them your child is not locked. You may have to wait until the priority date becomes current at a later on date.
Yeah, keep in mind the reason I think it's good to go through that full analysis is there's an entire book about the Child Status Protection Act, and so do I think there are some can the answer be simple? But I think it's you've got to go through all four steps. And Rahul's right. The I-140 being approved and when that'll happen, or Rahul, that's why we see a lot from the 2020 filers who downgraded, right? And that's they're thinking, oh, my child's locked. I filed my 485, everything's current. But when did that I-140 get approved? And that's something to keep an eye on.
How long can one stay unemployed on AOS? Please let me know. Actually, there is no law that says that if you are unemployed, the adjudicating officer can deny the application. Even if it's a period of 1 month period, the 485 could be denied. There are other creative solutions. If you are unemployed, there is a self-employment allowed. There is a job offer allowed. There are different circumstances. I would strongly recommend that you do not be unemployed. Try to find a way for self-employment if you can't find another job. Because if USCIS can deny the 485 application if they find out you're not employed. And people may ask question, how do they come to know? First, they can issue an RFE. Second, when you go for the 485 interview, they will ask a question. 5 years employment history, where were you working? Then you have to disclose that you're not employed. That is a grave danger for you.
Cyvern asks, currently on initial H1B valid until September 2024, extensions approved valid till 2027, original document in May, no approved I-140. Can I change my status to B1, B2? Yeah, I mean, if you are laid off, again, March 2023, I think completely changed this analysis. We used to say, don't do a B1, B2, you're wasting your money. It's silly. But what happened with the March 2023 guidance from USCIS is created a path for you to do that B1, B2 and make that work to go back to H1B. So strongly recommend you take a look at that. Options for terminated employees, non-immigrant employees, talk with a lawyer. But I think it's Cyvern, it's very possible to go to that B1, B2 before the end of the 60-day grace period.
The Explorer has this question. Can a dependent travel an EAD-AP while the main applicant is unemployed? First of all, Explorer, you have a bigger problem that you need to address. That is, being unemployed is very dangerous for the entire 485 application. Definitely, your child traveling is also a risk, or your wife or your spouse traveling is a risk. First of all, you need to cover your base to make sure you're self-employed, or you have a job offer or some kind of employment. Otherwise, you're risking the entire green card. Farouk Khan is asking this question. Currently, I have an H4 visa. Can I get admission to day one CPT University? we do not recommend day one CPT universities. We don't consider them as a good universities that you should go. I would suggest, Farooq Khan, to have your spouse get an I-140 approval as fast as possible. In that way, you can get a H4 EAD, because an H4 EAD is perfectly legal if your I-140 is approved, and you have a complete freedom of whatever you want to do, except what this guy has said, Stephen has said, is to work in marijuana industry. You have everything that you can do on the H4 EAD.
Sujit, and then actually, real quick, Furkan, if you are going to try to get a work authorization like CPT, which we don't recommend, you can't do that on H4 visa anyway. You can go to school all you want, I don't care. But working, you can't do that. You'd have to get an F1, so be cautious about that. A question from Sujit I've seen. Working on a J1 visa, waivers approved, want to switch to H4 with EAD. You can continue to work on the J1 until the H4 EAD is approved once you file for H4. Yeah, absolutely. Until the H4 is approved, you can continue maintaining your J1 status. So just keep an eye on timing, like I said earlier, with one of these cases, that if the H4 gets approved and the EAD is still pending, at that time you have to stop. But until that happens, you can keep working on the J1.
Question of the day that comes in is that is there a link between I-140 and applying a B2? This question is coming very frequently for those people who have a H1B approval and an I-140 approval. As Stephen has pointed out, from March of 2023, we have recommended people to apply for B2, have no issues moving on to B2 and moving back to H1B afterwards, which previous to March of 2023, it was a problem. Now, the main question that pops up is that for those people who have an I-140 approval, are we seeing any problem in getting the B2 approval? No, we are not seeing any problem whatsoever at all. We disclose it very clearly in the B2 application that the I-140 has been pending. We give them the receipt notice also, have no issues. A lot of people, what we recommend our office is that if you're filing a B2, you can file it online. And you can have a consultation, fill all the things and come to a lawyer and then go through the whole thing and boom, press the button, you file it online. And it's taking only two months, 2.5 months to get the B2 adjudicated if you file online. While if you file manually, it's taking 2.5 months just to get a receipt notice sometimes.
And Cyber, the issue used to be you can't have that immigrant intent with a B1, B2. And again, that is, this FAQ that they put out in March 2023 is fine. Abhinav asks, is it mandatory to maintain 40 hours on H1B? I'm doing school again while on H1B, but unable to maintain 40 hours per week. Employer's totally fine with it. Maybe. Your employer, if they listed your H1B as full-time and you are now operating under less and they're paying you less, then you need to do an amendment. If they're going to continue to pay you as a 40-hour a week full-time employee and they're like, hey, we're cool if you miss 5 hours a week, that's fine. But if they're going to try to pay, have you work less hours and pay you those less hours, that's okay. You just have to do an amendment.
CEO Sonic Solutions has that. I've been continuously employed for 12 years. Recently got laid off. I think so. He's on adjustment of status. Is that going to be a problem? He's trying to interview, will this be still a problem? It's not about whether you've been employed for 40 years, 50 years before. The question is that whether you have the job offer continuously after filing the 485 application. Since you don't have a job, the USCIS may conclude that you don't have a job offer. That's the reason you're not employed and they can deny the application. So the basic requirement for the 485 approval is that you must have a job offer. Since you're not working for any company at this point of time, then you may be risking. That's the reason why if you consult an immigration lawyer, you may get a solution. For example, self-employment may be a solution. I'm not telling that it's going to be easy one, but at least that has a better chance rather than being unemployed. How to document what to do about self-employment is where you need to consult immigration.
Yeah, very, very. It's not simple. You can't just wave your hand and say I'm self-employed. Right? It's very tricky in the immigration context. Naveen asked, we still had Filed a standalone EAD, filed and still pending. Later, a fresh H1, H4 EAD, all approved, or filed and approved what to do with the pending EAD. Naveen, you can either just forget about it or mail in a withdrawal. My expectation is it gets denied as moot because you don't need it, and they're going to say you already have the benefit. If you want to be proactive and send in a withdrawal that they won't process for about 2 months, you can. I don't think you have to.
Jay Shuristra has this question that he has an I-140 approval, but he is on student visa. Do you advise him to travel outside the country on student visa while the I-140 has been approved? I do not advise a person who has an I-140 approved to travel on a student visa. Very dangerous. I would not do that. Now, would I say the same thing for the H1B? Would I say the same thing for H4 or L1, L2? No. They can travel even after their I-140's approval if they are in H1, H4, L1, L2. Absolutely not a problem.
Abhinav, yes, we're happy to work with you on an amendment filing. Shoot us an email, info@rnlawgroup.com. We've got a great team, happy to help.
HF has this question. His graduate date is current, but he filed the medicals in 2021. Is it advisable to send the medicals even without an RFE? What I would suggest now, this is what I would do. I would not tell people because then they will say, hey, you wasted my money. I personally, though, I don't mind spending money. And I know that some people say, well, they're going to punch in the holes. For me, I don't mind these doctors punching the hole. Maybe they can punch in a couple of times. I'll get a little bit fever. I don't care. I want to get rid of the immigration law. I don't want to see Stephen in my life. Sorry, but he's a very nice guy. But as a client, I don't want to see him in my life all the time. Okay. For that reason, what I would recommend is that get the medicals, get 3 originals. So all you need to do is pay extra $20 and send one to the USCIS where your application is pending. Keep the other one because maybe you get an RFE, you can send the other one. That's what I would do, Stephen.
Yeah, I mean, that's what I've been recommending with some of our litigation clients. Same thing where they're, expired, go ahead, mail one in. We'll sue right away after you mail it in saying everything's good, everything's ready. And if they want to send another RFE, fine. I don't, whatever. You've already got a copy.
Shiva Tarun has this question. No I-140 perm initiated, but it's been 10 months. I got laid off. They might cancel the perm process. Will that affect anything or change anything for change of status? No, it does not affect anything on the change of status from B1 to B2. But however, you may want to look into if you're coming very near to 6th year of H1B, and then later on you want to extend the H1B, that may become a problem. But as far as moving to B1 and B2, absolutely not a problem.
Sindel, EB1, I-140, H1 approval, traveling to host country after a long stay, I assume in the U.S., 7 years. Will that impact your H1 stamping? No. H1B allows for immigrant intent. You can stay in the U.S., for however long. Obviously, you've got to eventually try to get a green card. But you can walk into the visa bulletin or to the visa office and say, by gosh, I want my H1B stamp. I'm going to get my green card as soon as I go back. And there's not a thing they can do about it from a legal perspective. It's totally fine that you've been here for 7 years. You don't have to show that ties to your home country like you do, for an F1 or a B visa.
Question, can you apply for H4 and H4 EAD from India? No, absolutely not. H4, you have to apply in the consulate anyway. H4 EAD, you have to be in the country for you to apply for the H4 EAD. What we suggest to some of the people who are busily employed in India, and if they want to claim the H4 EAD, they can just travel on H4 and then apply for the EAD and then go back. And once the EAD comes, you can come back. People ask me the question, if I travel outside the country and my EAD, H4 EAD application is pending, will it get denied because I traveled outside the country? The answer is no. It will not be denied. It will be adjudicated. Anything else, Stephen?
No, I'm good. Again, take a look. I did a video on that Chevron thing. I don't think it's as crazy as everybody thinks it is.
Where is that video, Stephen? I didn't see that.
Yeah, I'll send you the link. We did it on YouTube with a podcast, Area 51. They are, it's two guys, two Indian nationals that wanted to start a podcast to inform people. Very fun group of guys. And we just talked last night on the case and how it might impact immigration going forward.
And if you want to speak with Stephen, me, or any of my colleagues, there is a link there. All of our schedules are available online. You can block a time that suits you. Thank you very much for tuning in. We'll see you next week. And don't forget, from July 14th onwards, we will be having Sunday night from Reddy Neumann because we don't have a TV show coming forward anymore. So we're going to do from Reddy Neumann Sunday night show. Thank you very much.